Welcome to New Unrealist. Some semblance of sanity has been brought back into the legal courts of England and Wales. Now, for those of you who are not aware, Tommy Robinson is a 35-year-old activist in the United Kingdom who was reporting on the trial of a Muslim rape gang earlier this year in Leeds Crown Court over in the United Kingdom. He was live streaming video on Facebook from in front of the courthouse, and he was engaging the defendants of the trial as they walked into the front entrance of the court. Now, after 40 minutes or so, police came over and arrested Tommy Robinson on some trumped-up charge of breach of peace or whatever. Then, in one of the swiftest trials likely in the history of the United Kingdom, within barely 3 to 4 hours, Tommy Robinson was being put into the back of the police van. He was on his way to prison for a 13-month prison sentence of contempt of court. 10 months for the arrest that day, and another 3 months on a suspended sentence for a previous sentence for contempt at another court. The man was sent to rot in prison for over a year for simply conducting an act of journalism commonplace and done every day throughout the Western world. Reporters standing in front of courthouses and questioning defendants as they walk into court. See Paul Manafort if you want to see an example of how that works. In an extraordinary ruling, the Lord Chief Justice of England and Wales, the equivalent of the Chief Justice of the Supreme Court, John Roberts, here in the United States, the Lord Chief Justice of England and Wales, Lord Burnett of Malden himself, ruled that the series of events which resulted in the near immediate incarceration of Tommy Robinson earlier this year over that minor infraction that I described was a fundamentally flawed process. The Court of Appeal also ordered that the case be taken away from that judge and reassigned to another judge. A stunning rebuke. The long and short of the decision is that Tommy Robinson is being freed on bail with the condition that he stay away from the Leeds Crown Court where he was arrested to a minimum distance of 400 meters, nearly half a kilometer, until he can get a new hearing. I'll read the meat of the ruling's conclusion. For the reasons we have given, we are satisfied that the decision at Leeds Crown Court to proceed to committal to prison so promptly and without due regard for Part 48 of the rules gave rise to unfairness. There was no clarity about what parts of the video were relied upon as amounting to contempt, what parts the appellant accepted through his counsel amounted to contempt, and for what conduct he was sentenced. Indeed, he would emphasize that save for those cases involving obstructive, disruptive, insulting, or intimidating conduct in the courtroom, or its vicinity, or otherwise immediately affecting the proceedings, the judge, having taken such steps as are necessary to bring the misconduct to an end and mitigate its consequences, should usually resist the temptation to initiate contempt proceedings on his or her own motion. In the circumstances of this case, whilst the judge was entitled to deal with the contempt himself, the urgency went out of the matter when the appellant agreed to take down the video from Facebook. There should have been an adjournment to enable the particulars of contempt to be properly formulated and for a hearing at a more measured pace, as had happened in Canterbury. The judge might have referred the matter to the Attorney General to consider whether to institute proceedings. That course would have avoided the risk of sacrificing fairness on the altar of celerity. If you don't know what celerity means, it means it's an old antique word for speed. The Lord Chief Justice wrote in the body of the document several points which need to be repeated. The Chief Justice noted that the jury in the grooming gang case had already retired for deliberation, so the trial was effectively over, meaning there was no reason for urgency or to take special steps to safeguard interference with the trial. The jury already had the case and was deliberating already. It was also noted that Tommy's legal representation was found during, and I'm not making this up, a 33-minute adjournment. Imagine, you're hauled up in front of a judge, literally dragged in right off the street, and the judge pauses your hearing for only 33 minutes, in which time you have to get a lawyer, explain your side of the case, and have that lawyer come up with a defense for you for the trial. All in the space of 33 minutes. Insanity. The particulars of the contempt, they were not put to the appellant. That's Tommy. And the appellant was not given the opportunity to admit or deny the contempt. So the judge ruled that Tommy was not even told what he did specifically that put him in contempt nor was he allowed to admit or deny the contempt. I mean, what was this, a kangaroo court in some third world banana republic? The ruling also notes that the judge ought not have commenced the contempt hearing that day because there was no urgent reason to do so once Tommy Robinson took the video down from Facebook. The judge makes it very clear also that there was, quote, a muddle over the nature of the contempt being considered and that, quote, there was no clarity about what the appellant was admitting or on what basis he was being sentenced. Finally, I want to note that the Lord Chief Justice wrote that, quote, the order at Leeds Crown Court was also erroneously drawn up to suggest the appellant, again Tommy, had been convicted of a criminal offense rather than having been committed for contempt of court. It's amazing. Deliberately fudging the documents to turn Tommy Robinson into a criminal. Bottom line, the Court of Appeals ruled that the finding of contempt in the Leeds Crown Court is quashed. Tommy is granted a new hearing at a new venue in front of a new judge. He's to be released on bail with the condition that I mentioned earlier where he must stay away from the Leeds Crown Court pending his new hearing. The Leeds conviction was in fact now officially deemed illegal by the highest court in the UK. Good job by Tommy's lawyer, Jeremy Dine, who represented him in this proceeding. Tommy learned of the success of his appeal from his fellow inmates at the prison he was being held in. They started to chant his name, made quite a ruckus apparently. He phoned his family, they confirmed to him, yes, it was true, and that he was going to be let out of the prison and that they could go on that family vacation that they'd already bought and paid for before he went to jail, scheduled to start this Friday, August 3rd, 2018. He let it be known through Facebook that he thanks everyone who campaigned for his release and supported his struggle to appeal the case. That's all for this New Unrealist. Like the video, comment, subscribe to the channel, and hit the notification bell to keep up with new content on it. Thanks for watching.